had not they derived any authority after the State Health Commissioner, Dr. Oliver, had issued the order to all public schools in June 2020 to submit plans, consistent with the Centers for Disease Control and Prevention and Virginia Department of Health mitigation recommendations, including first and foremost, policies and procedures for the use of face coverings. Could anyone reasonably debate the proposition that COVID-19 spreads from person to person, transmitted via respiratory droplets, and can be spread from an infected person who does not have symptoms to another person, or describe the commonsensical measures of masking guidance as in any way arbitrary or capricious, or an abuse of discretion? This may be first a test of your reading comprehension skills, because by June 2020, the definitive statement from the State Health Commissioner that COVID-19 spreads from person to person, transmitted via respiratory droplets, had departed from CDC guidance in May 2020, which merely stated, in the passive voice, that the virus is thought to spread mainly from person to person, between people who are in close contact with one another, within about 6 feet, through respiratory droplets produced when an infected person coughs, sneezes, or talks, and perhaps Dr. Oliver was one of the persons who had thought that, and even doctors, sometimes, make mistakes.
And under the law, what would be the consequences of obeying an unlawful order? At least in the military, in the case of Lieutenant Calley, it was that court's conclusion that even a soldier must use common sense and the acts of a subordinate done in compliance with an unlawful order given him by his superior are excused and impose no criminal liability upon him unless the superior's order is one which a man of ordinary sense and understanding would, under the circumstances, know to be unlawful, or if the order in question is actually known to the accused to be unlawful. Moreover, defining duty, in 1872, in the matter, Cordova versus Hood, the U.S. Supreme Court had held that means of knowledge with the duty of using them are, in equity, equivalent to knowledge itself.
What is so bad about being mandated to wear a facial covering at school? The Supreme Court had considered a similar situation in the case, Tinker v. Des Moines Independent Community School District. According to the court, in December 1965, a group of adults and students in Des Moines held a meeting, and the group determined to publicize their objections to the hostilities in Vietnam and their support for a truce by wearing black armbands during the holiday season. However, the principals of the Des Moines schools became aware of the plan to wear armbands, and, on December 14, 1965, they met and adopted a policy that any student wearing an armband to school would be asked to remove it, and, if he refused, he would be suspended until he returned without the armband. In West Virginia v. Barnette, the Supreme Court had decided that, under the First Amendment, the student in public school may not be compelled to salute the flag, and in Tinker, the court emphasized that the issue did not concern wear of apparel, or even hairstyles, and did not concern aggressive, disruptive action or even group demonstrations. In fact, only a few of the 18,000 students in the school system wore the black armbands, and only 5 students were suspended for wearing them. And Justice William Brennan, Jr., drafting the opinion for the court in Keishan v. Board of Regents, had reiterated from Shelton v. Tucker that the vigilant protection of constitutional freedoms is nowhere more vital than in the community of American schools. The classroom is peculiarly the marketplace of ideas. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas which discovers truth out of a multitude of tongues, rather than through any kind of authoritative selection. And striking down the ban against armbands, the Supreme Court upheld the First Amendment rights of students, and the idea expressed by the court in Barnette, that if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein, for, as stated in Stanley v. Georgia, you are whole constitutional heritage rebels at the thought of giving government the power to control men's minds. And, in Tinker, the Supreme Court had held that, in the circumstances of the present case, the prohibition of the silent, passive witness of the armbands, as one of the children called it, is no less offensive to the Constitution's guarantees. However, in Commonwealth v. Pleasance, the Virginia Supreme Court had distinguishing facts, and had concluded that when a protest demonstration became unduly disruptive of the educational process and of good order and discipline in the school, it became not only the right, but the duty, of the principal to take reasonable measures to restore order so that the educational process might continue, upholding the authority of the public schools to ensure the proper administration of education, which Chief Justice Earl Warren, in the landmark decision of Brown v. Board of Education for Topeka, Kansas, had described as perhaps the most important function of state and local government. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. And such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. Clearly, as stated in RGR v. Settle, where the defendant by some action on his part, creates, maintains, or continues a risk of physical harm, the general standard or duty is the duty of reasonable care, that is, the duty to avoid negligent conduct. Recognition that a duty of care is ordinarily owed to avoid conduct that creates risks of harms to others is the majority view of both courts and commentators. Would they have been negligent not to mandate the wearing of non-medical grade facial coverings? If you believe it would have been negligent for the Arlington public schools, in a matter of degrees, as stated in Marston v. Barnes, there are 3 levels of negligence, and the first level, simple negligence, is defined as the failure to use the degree of care an ordinary person would exercise to avoid injury to another. Gross negligence, the second level of negligence, is defined as action which shows indifference to others, disregarding prudence to the level that the safety of others is completely neglected. Gross negligence is negligence which shocks fair-minded people, but is less than willful recklessness. The third level, willful and wanton negligence, is acting consciously in disregard of another person's rights or acting with reckless indifference to the consequences, with the defendant aware, from his knowledge of existing circumstances and conditions, that his conduct probably would cause injury to another. And only such a reckless disregard would sustain a charge of criminal negligence. What level of negligence would have been committed had the Arlington Public Schools decided not to follow the guidelines of the CDC and the State Health Commissioner? In the alternative, should you consider it negligent of the school board to have implemented the masking mandates, essentially an unlawful order that a person of reasonable sense and understanding would have known to disobey? The Eighth Circuit had held, in U.S. v. Lutheran, that mere acquiescence or silence or failure of an officer to perform a duty does not make one a participant in a conspiracy unless he acts or fails to act with knowledge of the purpose of the conspiracy, and with the view of protecting and aiding it. And, even the Fourth Circuit in Richmond had observed in U.S. v. Chalk, that all power may be abused if placed in unworthy hands, and courts cannot prevent abuse of power, but can sometimes correct it.
This message was approved by Major Mike Webb. Honest.